Welcome to Caregiver Counsel, Elder Law Insights with Tieesha Taylor.
Welcome back to Caregiver Counsel, Elder Law Insights with Tieesha Taylor. I am Tieesha Taylor, founder and CEO of the Elderly Care Law Firm here in South Florida, where we provide compassionate generational legal services to families navigating Medicaid, guardianships, probate, and long-term care. Joining me today is Stephen Garcia-Vidal, a senior associate here at Elderly Care Law Firm. Stephen has been practicing law in Florida since 1998 and focuses on wills, trusts, probate, guardianship, and estate planning. Today, we're talking about guardianship and what families should understand when a loved one may no longer be able to manage their own decisions. Welcome, Stephen.
Welcome, Tieesha. Thank you for having me. I'm excited about being here.
Great. Now, Stephen, can you just start with just describing what situations usually lead families to begin considering guardianship for a loved one?
It's a great question. Guardianship is a significant court-appointed legal step in Florida designed to protect the individuals who can no longer manage their own affairs or due to incapacity such as advanced dementia, severe injury, or developmental disabilities. It's always the last resort. So it's never the first choice. It's always the last resort. And the court will always consider what they call less restrictive means, or that those less restrictive means are insufficient and therefore guardianship is the next step.
Mm-hmm. Okay. Now, families often struggle to tell the difference between like normal aging and a situation where someone truly needs legal protection, like through a guardianship. What signs tend to raise concern?
Signs that an aging loved one may need legal protection rather than just assistance with normal aging include cognitive decline, confusion, forgetfulness. And I'm not just talking like what they say about a senior moment, like my dad used to say. I'm talking about constant forgetfulness, unmanageable financial changes, unpaid bills, scams of people trying to take advantage of the person, physical neglect, poor hygiene, unexplained injuries. Other indicators are isolation, people calling and anxiously changing legal documents, or an intense new reliance on a specific person. Those are usually the signs.
Okay.
Besides aging.
Yeah. And then, that's a great list. As I was going through it, I was trying to think of myself, were there anything else? But yeah, I think you hit it all. Now, before guardianship becomes necessary, what legal tools sometimes allow families to help with decision making before guardianship even is considered?
Yes, that's a great question too. Because before guardianship becomes necessary, families should consider what our firm offers in terms of durable power of attorney, the legal documents, healthcare designations, medical, and supported decision-making agreements to allow trusted individuals to help with the decisions. These will avoid court involvement, maintain the individual's independence, and are less restrictive. If you don't, and of course, in these documents, you can name a pre-need guardian, and as opposed to the court naming the actual person.
Great. Now, have you seen situations where a family waited too long to explore guardianship and then had to make decisions during a crisis? And if so, what tends to happen in those moments?
That's a great question. Yeah, some people wait till last minute to explore guardianship, and a common scenario often forces families into high stakes. They might end up contesting the guardianship, stressful situations, and they must make decisions during a crisis rather than careful planning. So I've seen it where instead of just doing a durable power of attorney or a healthcare surrogate, ones that survived what they call incapacity, which is the reason, the trigger for guardianship, they can just do it in a relaxed atmosphere at our law firm, and come to the conclusion that it's not going to be contested and there'll be direction. In other words.
Got it. Yeah. And then once a guardianship case is filed, what does the court process typically look like in Florida?
That's a great question, Tieesha. I always educated people on how guardianship is set up. It's a two-part process. You have incapacity on one side, on the other side, you have guardianship. It begins by filing a petition to determine incapacity and a petition for appointment of guardian. I've seen it where sometimes the courts, even before we had Zoom and video conferencing, you would get to the incapacity hearing and the judge would ask you, did you file the guardianship documents? And you'd say, Your Honor, we're in the process of doing that. Now they want everything done all at once. So you can actually file the petition for incapacity, get a case number, it's a mental health case number, and then also file the appointment for guardianship, the petition for appointment of guardian. And the court will probably sign it right after the order determining capacity is signed. The court appoints for the AIP. You cannot call that person a ward yet. It's alleged incapacitated person and no doctor can determine if a person is incapacitated. I know there are doctor reports, but nevertheless, the only person that can do that is a judge. And of course, they have a 3-member examining committee, which evaluates them. So they have, most of the time, it's one MD doctor and 2 psychologists. And a hearing is done within, or scheduled within 30 days. They're pretty fast about that. And then, of course, it typically takes 60 to 90 days in total by the time the guardian is appointed. So we don't like to promise anything before that.
Great. Wonderful. Thank you for that explanation of the process. Now, when someone is appointed as guardian, what responsibilities do they take on?
That's a great question too, because what its responsibilities are they have to understand that it's not just like running down to the supermarket and getting some bananas or a salad. The court appointed guardian assumes legal responsibility for managing the personal, medical, and financial affairs of the minor. We do also guardianships for minors that are under 18 or an incapacitated adult. Most of my guardianships are incapacitated adults. Some minors are there, but that's usually when you have an award of a personal injury lawsuit or a big number, and again, it's more than $15,000, and they have to set up a guardianship for that. Acting in the guardian has to act in the best interest of the AIP, and then of course the ward once the court has signed the order. And what it ensures, or the key responsibilities that are not necessarily guaranteed, but they have to be almost guaranteed, are proper care, food, shelter, education, and medical treatment, alongside managing the assets. So it's a big responsibility. And they have to file regular reports. I'm going through that right now with all the deadlines coming up April 1st. It's almost like tax season. We have to follow what they call the annual reports and the annual accounting. If any of those are waived, you don't have to. But nevertheless, the annual report, the guardianship report, is required, and an annual exam is also required. And what happens is it has to be within 90 days. What they don't want is to see someone examined a year ago and then come back now, file a report, and then what happens is they're not in good shape. So I can attest to that with family members. So that's why they want it within 90 days.
Now, if a family believes guardianship may become necessary soon, what early conversations or planning can make that transition easier?
That's another great question. To make guardianship easier, if they're at that step and there's no least restrictive means that could be imposed, like I remember from the chief judge from Miami-Dade County, Maria Corvick, always used to say the least restrictive means, and before she signed that order. What families should do is open a sensitive conversations with potential guardians, document wishes, and explore alternatives to court involvement, such as durable powers of attorney, like I mentioned, to ensure a smoother, less costly process. The key points, identifying these trusted individuals to serve as guardians, formally documenting these choices in legal documents, and reviewing options with an experienced attorney, not just myself, but any attorney who has definitely experience. We definitely prefer our firm to balance safety with independence. So it is a big step. I think it should be reviewed by an attorney, the loved ones in front of the person who's the AIP, if possible, and do those documents. And what the attorneys will assess at that time will be if the person has capacity. I've seen it. I've had cases where the AIP, by the way, is also gets a court-appointed attorney, regional counsel, or a volunteer from the legal community. And what you'll find is that the guardian ad litem has to serve in the best interest of that AIP, and usually there's another report done. But what you want is you want to make sure that person is definitely ready for that. But my point is, when you have someone that has incapacity, the attorney that's going to represent the guardian as opposed to the AIP, again, that's alleged incapacitated person, should not maybe not draft what they call least restrictive mean documents. If they have some capacity, I mean, if they can recite their social security, their address, who's the president, as opposed to having a situation when I was an AIP counsel, I had the attorney for the guardian call me and say, why don't we just on the side, and this was already the mental health hearing was already set, would you mind approving that we can do some more durable power of attorneys trust for the ward, for the AIP, of course, not the ward yet. And I said, absolutely not, because I cannot go before the judge until I approve that. That would definitely have been something that's wrong.
Yeah.
So you have to be very careful in those situations. We've had clients that call us and say, can you have these documents signed? And the person is questionable with their incapacity. And again, the court's only can determine that with the evaluation of those 3 doctors, but you can tell if somebody is just not well and
Yeah.
doesn't have capacity. And then therefore, if you draft those documents, any attorney that does that is not ethically, they shouldn't do it.
Okay, thank you. Yeah, that's important to mention. Now, is there anything else? I know you explained a lot, so thank you for that. But is there anything else you think our audience should know regarding guardianships that would be helpful for them?
The one thing to understand about guardianships, thank you, Tieesha, is a great question. It's kind of like you want to see if you have a medical condition, something that's bothering you, you want to see the doctor, not the medical system. So I think in this case, if you have a guardianship issue, seek out an experienced guardianship attorney like myself, and of course the elderly care law firm. We can do that for you. And talk. Don't be afraid to talk. Sometimes these are hard decisions. I know that with my estate planning, sometimes it's hard to talk to my spouse about it, get the kids involved. It's just finding the time, but it has to be done because when we come in at the last minute, I've had a situation where the person had maybe 2 weeks, 3 weeks to live. We did an emergency guardian, which can be done. The courts appointed an emergency guardian. It's almost like a guardianship set up in advance, and then they have that hearing, and the person died 2 weeks later. That was very stressful, and it was just not a good situation.
Yeah.
The person didn't stop drinking water, stop eating. So it just, why wait? Why would anybody wait to that point? I mean, so my suggestion is always to see an experienced attorney. Make sure you deal with all the questions, just like you would if you had a medical condition, and find out the truth. And that's what we do here at LG Call Firm. We tell the truth.
Thank you. Yeah.
And give the best advice, of course.
Thank you. If someone wants to reach out to you or have more questions about guardianships, how can they reach you?
They can call the law firm. My number is 786-363-1580. Call me directly and we'll put them in touch with the intake team. And there's a general number also. They can dial 305-836-4697. Visit the law firm website, elderlycarelawfirm.com. And someone will reach out to them. And definitely we'll set up an appointment.
All right. Well, thank you, Stephen. And thank you for providing all that great information regarding guardianships. I know it's going to help a lot of people in our audience. So thank you for sharing that and joining me on the podcast today.
Anytime, Tieesha. Look forward to the next one.
Now, thanks for listening to Caregiver Counsel Elder Law Insights. If you're facing questions about long-term care, Medicaid, guardianship, or protecting an aging loved one, you can connect with my team at 305-836-4697. Or take a look at our website at elderlycarelawfirm.com. And if this episode was helpful, please subscribe, leave a review, and share it with someone who might need it. We'll see you next time. Bye-bye.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.